who manages the funds for a minor beneficiary. Have you ever wondered what happens to funds left to a minor beneficiary? When a minor is named as a beneficiary in an estate plan, they cannot manage or control the inherited funds themselves. This is because minors do not have the legal capacity to handle financial matters. So, who takes charge of these funds until the minor comes of age? The management of these funds is entrusted to an adult or legal entity acting on behalf of the minor. This arrangement continues until the minor reaches the age of majority or another age specified in the estate plan. There are several ways to manage funds for a minor beneficiary, and each has its own benefits. One common method is through a trust. A trust is set up specifically for the minor beneficiary, and the person creating the estate plan, known as the trustor, appoints a trustee. This trustee is a fiduciary responsible for managing the trust assets for the benefit of the minor. The trustee controls, invests, and distributes the funds according to the terms outlined in the trust document. This approach allows for flexibility, such as delaying access to the funds until the minor reaches a certain age or meets specific conditions, like completing their education. Trusts also provide professional management and ensure that the minor's inheritance is handled wisely. Another option is to use custodial accounts, such as those established under the Uniform Transfers to Minors Act or the Uniform Gifts to Minors Act. In this case, a custodian manages the assets on behalf of the minor until they reach the age of majority, which is typically 18 or 21, depending on the state. Custodial accounts are generally easier to set up but offer less control over when and how the funds are distributed compared to trusts. If no trust or custodial account is established, a court may appoint a legal guardian or conservator to manage the minor's inheritance. This guardian has a fiduciary duty to protect and manage the assets responsibly until the minor becomes an adult. The guardianship process involves court supervision, which can be more complex and costly. It may also lead to disputes among family members about who should serve as guardian. For inherited retirement accounts left to minors, special trust arrangements can be created to manage distributions. These trusts can help extend control over the assets beyond the minor's legal adulthood and comply with laws like the Secure Act. Such trusts allow for professional management and can provide tax advantages along with creditor protection. Practical applications in estate planning highlight the importance of establishing a trust or custodial arrangement when naming minors as beneficiaries. This ensures that the inheritance is managed responsibly and protects the minor's interests. It can also prevent unintended consequences, such as the loss of government benefits or the premature depletion of the inheritance. In summary, funds for a minor beneficiary are managed by a trustee, custodian, or court-appointed guardian who acts in a fiduciary capacity until the minor reaches adulthood or another specified age. Establishing a trust is often the most effective way to control how and when the minor receives the inheritance, providing legal protections and financial oversight aligned with the estate planning goals.